Hello friends, in the series on the income tax cases, today we will discuss a very important case of Principal Commissioner of Income Tax versus Reeta Lakhmani. This case has been reported in 457 ITR page number 603 and the matter has been decided by Calcutta High Court and the date of the judgment is 22nd November 2022. I have seen in my practice that whenever the orders are challenged, the grounds of appeal are not taken properly. And sometimes, because we do not take the ground in a proper manner, then there is every possibility that we may lose the case. How strong the case in favor of the assessee or how strong the case in favor of the department is. So, taking the ground and how to challenge the order is very important. In this case, the department lost its appeal only because of the reason it was not challenged in a comprehensive manner. It was challenged in a piecemeal method. The facts of the case are very interesting. In this case, the appeal of the assessee in the ITAT was allowed by the ITAT on two grounds. The assessment order was revised by the Principal Commissioner of Income Tax under Section 263 and the matter involved was penny stock. The ITAT said that in the present case, the revision under Section 263 was done on the instance of the assessing officer, while the jurisdiction of Section 263 says that it should be at the instance of the Principal Commissioner of Income Tax, meaning thereby that the Principal Commissioner of Income Tax has to call the records and then has to take the call whether the revision is to be done or not. But if the assessing officer goes to the Principal Commissioner and says that the order passed was erroneous and prejudicial to the revenue, so this should be revised and accordingly PCIT revised the order, then this is not the way. So on this ground also the ITAT gave relief to the assessee that the order which was passed in accordance with the direction of the PCIT under Section 263, that was not according to the provision of Section 263. And the second point was that the ITAT also gave relief to the assessee on the matter of penny stock on the merits also. The ITAT was convinced that whatever the documentation the assessee has done, the assessee should get the case. So the assessee got the relief on both the grounds, on the ground of jurisdiction of Section 263 and on the ground of merits also. But when the department filed the appeal before the Calcutta High Court, by taking the shelter of the decision of the Calcutta High Court itself in the case of Principal CIT versus Swati Bajaj, which has been reported in 456 ITR at page number 56, because this judgment was in favor of the department and it was on the penny stock. So there was very fair chances that the department may get the case in the Calcutta High Court if both the grounds have been taken. But in the present case, the department has challenged the ITAT order only on the second ground, that is on merits, and not on the ground of revision under Section 263. So in this case, the Calcutta High Court said that the department is not allowed to challenge the order of the ITAT on a piecemeal method. And if the department do not challenge the first ground, that is the technical ground, that is for the jurisdiction of Section 263, it means that if the department is not challenging that ground, it can be interpreted that the department has reconciled with the reasoning given by the tribunal on that ground, and in a comprehensive view, this appeal should not be admitted because the department is challenging the order of the ITAT only on one ground and not on the other ground. So it can be safely interpreted that the department has accepted the order of the ITAT on the first ground. So the Calcutta High Court dismissed the appeal of the department and said that there is no need to hear the second ground because the assessee get its case on the first ground which has not been challenged by the department, and that is on the jurisdiction of Section 263. Friends, this case throws light that how we should take the grounds. We may be very strong in our case, but if we have not taken the grounds properly, then it can be it can have very serious consequences on our case. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Reeta, Lakhmani, and this case has been reported in 457 ITR at page number 603. The matter has been decided by Calcutta High Court and the date of the judgment is 22nd November 2022. Thank you, friends.